We are students of Holmes Institute, Sydney. We are presenting a business law case for our group assignment for business and corporation law. The presentation is on the case of ASIC and Rich. We are 5 members in our group. The case is between Australian Securities and Investment Commission and Mr. Jody Rich of OneTel Company. It was one of the largest civil cases of New South Wales. The legal process ran for almost 9 years. The case was filed in 2001. The final decision was made only in 2009. It took up to 232 sitting days and generated 16,642 pages of transcripts. So it is beyond this presentation to discuss the case in detail. We will try to summarize in short. The judgment was broadly reported in the general media and various papers. The trial cost the Australian government over $35 million. The final judgment date was on 18th November 2009. The plaintiff was Australian Securities and Investments Commission or ASIC. The first defendant was Mr. John David Rich, known as Jody Rich. The fourth defendant was Mr. Mark Allen Silverman. We will talk later about other defendants. These were the counsels and solicitors for the plaintiff and defendants. Moving on to brief profile of the company OneTel. OneTel was a supplier of GSM versatile and long-distance calls. It was formed by John David Rich with Brad Keeling in Australia in 1995. James Packer and Lachlan Murdoch were major shareholders. It was backed up by Optus, which was then the second largest telecommunication company in the country. The company grew to be the fourth biggest Australian telecommunication company with 3 million subscribers, 3,000 workers, operation in 7 nations and over 1 billion yearly turnover. But in March 2000, the company invested further 523 million Australian dollars in purchase of additional Australian spectrum license. In the end of financial year of 2000, that is in June 2000, the company was in loss by 291 million Australian dollars. In May 2001, following the emerging problems of the company, Packer and Murdoch withdrew their support from the company. According to the administrator's report, the company was already insolvent by March 2001. It was speculated that if the company got assistance from the major shareholders, it would have still run till November, and by then the company could have generated cash flow to grow on its own. However, OneTel ceased operation in Australia in June 2001. In the same month, ASIC obtained criminal warrants against the
directors and chairperson of OneTel company in 2001. ASIC alleged that the officers had breached their duties of care and due diligence under sections 180, paragraph 1 of the Corporation Act 2001 by failing to properly assess OneTel's financial position, inform the board about OneTel's true financial position, ensure the existence of systems facilitating the follow of financial information to the board. We would like to briefly discuss Corporation Act 2001, Section 180, Paragraph 1. It describes about care and diligence of directors. It states that a director or the officers of a corporation must exercise their powers and discharge their duties with the degree of care and diligence that a reasonable person will exercise if they were a director or officer of a corporation in the corporation circumstance and occupied the office held by and held the same responsibilities within the corporation as the director or officer. The pleading responsibilities of the defendants were to monitor management, properly assess the financial position and performance of the group, delete and assist adverse developments affecting the group's financial performance, to inform directors of materials information. The pleading, especially for Mr. Rich, were to ensure the proper systems were established, maintained and monitored to procedure accurate and reliable financial information following from management to the board, not to mislead the board and withhold materials financial information for it, to ensure the OneTel compliant with the continuous disclosure obligation of a listed company under the as-listed rules and the corporation law, to ensure that the group's cash reserves were maintained at a significant level. The proceedings were initially brought by ASIC against 4 defendants. The action against 2 of the defendants, joint managing directors Bradley killings and non-executive chairs John Greaves were settled previously. To establish a contravention against respectively Mr. Rich and Mr. Silverman, ASIC have to prove Mr. Rich was a director or other officer of OneTel. The responsibilities attached to the officer occupied by him. He exercised powers or discharged duties in the office during the relevant circumstances. He did not do so with the degree of care and diligence that a reasonable person would have exercised as a director or officer of a corporation in OneTel circumstances. As he sought the following relief in relation to the alleged contraventions: civil penalties, banning orders preventing the defendant from holding future company directorships, comprehension in the amount of $92 million on behalf of the company's creditor for losses, alleged to have resulted from the alleged contravention by the defendants of their duties of due care and diligence.
The defendants, Rich and Silverman, focused on ASIC's failure to prove its case as pleaded. The defendants also relied heavily on the business judgment rule contained in Section 180, paragraph 2 of the Act. The rule provides a defense where commercial decisions are made as long as there is a rational belief that the business judgment is in the best interests of the company. The Corporation Act, Section 180, paragraph 2 is about business judgment rule. Business judgment rule states that a director or other officer of a corporation who makes a business judgment is taken to meet the requirements of subsection 1 and their equivalent duties at common law and in equity in respect of the judgment if they make the judgment in good faith for a proper purpose and do not have a material personal interest in the subject matter of the judgment and inform themselves about the subject matter of the judgment to the extent they reasonably believe to be appropriate, and finally rationally believe that the judgment is in the best interests of the corporation. This rule is capable of providing a defense for directors whose conduct breaches Section 180, paragraph 1. It provides insurance where a director makes a business judgment that an executive practicing sensible consideration would not make in the conditions, but rather where the specific director in any case normally trusted that the strategy to be to the greatest advantage of the company. Moving on to the trial, a great deal of the evidence and hearing time was concerned with the financial position of the company in January to April 2000, which was significant for both parties. It is stated that as at 28th February, the company required a cash injection of $270 million, which rose to 287 Australian which rose to $287 million as at 31st March and $309 as at 30th April. It was also alleged that the monthly flash reports were false and misleading. The flash reports were a monthly summary of financial reports supplied by OneTel to the board. It was also alleged that the March board papers were false and misleading. There were numerous witnesses for ASIC, like James Packer, Lasland Murdoch, Brian Long from Ernst & Young, who gave the audit report. However, most of the evidences from these witnesses were considered to be unreliable, incoherent and inconsistent.
The trial concluded on 18 November 2009. Justice Austin stated that ASIC failed in every aspect of their case, failed to call key witnesses and exaggerated the effect of evidence or misleadingly took passages of evidence out of the context. He further stated that ASIC's contentions have a superficial appeal, but time and again they were shown to be unpersuasive when the underlying financial detail was investigated. He decided that ASIC's summary of Mr. Rich's evidence in the witness box was inaccurate, thus he granted judgment for the defendants. Justice Austin, in his judgment, provided the first comprehensive judicial analysis of the statutory business judgment defense in Section 180, Paragraph 2 of the Corporations Act 2001. Justice Austin concluded that the burden of providing the four elements of the business's judgment rule rests on the defendant, informing oneself about the subject matter. In relation to this element of the rule, Austin J. made the following comments. The qualifying words, to the extent they reasonably believe to be appropriate, convey the idea that protection may be available even if the director was not aware of available information material to the decision. If he reasonably believed he had taken appropriate steps on the decision-making occasion to inform himself about the subject matter, rational belief as to the best interest of the corporation. ASIC contended that the terminology of rational belief should be equated to a reasonable belief, which was rejected by Austin J. As such, an interpretation would be render the business judgment rule useless, as the rational belief element would only be satisfied in circumstances where there was a reasonable belief, in which case there would be no contraventions of the Section 180, Paragraph 1 reasonable person duty of care and diligence. In other words, the rule has real work to do in that the rational belief standard is a lower standard than the objective to reasonable person standard of the duty of care and diligence. The major significance of this case was that during the case, the High Court made new law regarding the procedural rights of defendants in civil penalty litigation. The new law declared that in such cases, ASIC banning orders are to be considered penal in nature, rather than protective, and as such, any disqualification from ASIC can now be considered unconstitutional. To conclude, this judgment and the verdict to which it leads are the product of civil legal proceedings conducted in accordance with our advisory system. The court had not been asked to determine at large who was to blame for the disaster, as amongst the defendants, other executives, non-executive directors, major shareholders and advisors. These are the references. Thank you very much.